right, we're back in session, Sheriff.
Next series come to order. We're back in session. If you have a cell phone or any other electronic device, there will be no photographs or audio recording during session report without the court's permission. If friends or family or whoever comes in after this announcement, please advise them of such. Thank you.
Thank you, Sheriff. We're not going to bring the jury back in until you have everything that you need there, Mr. Charles.
Thank you.
Closing. If you have a chance to look at those verdict sheets,
Mr. John,
you're doing that right now, Mr. John?
Yes, sir.
And Mr. John and Zealous, y'all are looking at them right now.
Yes. Your Honor, the state has no objection.
All right.
We wanted to look at the indictments. Which one was that?
You need to look at the files, see what you
Having
need.
trouble finding 70 and just seeing if the jury instructions line up with the indictment. So
Here's number 70.
thank you.
Yes, sir.
The feng shui of my files is falling apart. Of course, it's destroyed. Okay. Thank you.
Yes, sir.
Thank you for placing things.
Yes, sir. Let me know when you your things together there, and we'll get started.
I'm ready, Rumor. Thank you.
Thank you. All right, Sheriff, can you?
Yes, sir.
Or let the record reflect all our jurors back in their seats. Mr. Barnes, would you repeat?
Thank you, Your Honor. Good afternoon. Shell game cover up railroad train. Heard the train go by. The push in this case to convict him has been intense. And it continues until you take the case and you're going to make a decision. And you're going to make a decision based on the evidence, based on what the judge instructs you, and you are the finders of that. So it doesn't matter what I say, if it doesn't convince you, if it doesn't come from you, you're not going to do it, just like you're not going to do it for the prosecutor. But let's talk about a couple little things that are unusual in this case. One is the chase policy. If the chase policy is must the person running is armed, and they're a murderer, a kidnapper, something of that sort, as Mr. Donovan will join me. and he's in that car, and that car door is open. The door is like this. Officer isn't in front of the door, and the car has been on the whole time, which is an indication that the officer didn't see any problem with this gentleman, because he's been searched, he has no weapon, the only person that has a weapon is Officer Stewart. So the car's running, the officer's outside, the door's open, and even if the officer's hands are somewhere like this, what do you have to do to jump on to a moving car on an incline? You have to chase, you have to violate the policy. And that's assuming if you actually believe the officer. Let's talk about something else that's concerning, that doesn't fit. This issue of, are there burns, injuries to Carlos Riley's hands? And Corporal McMaster said there was not. And if you will take this replica, and this is not a replica of a Smith & Wesson, we were told it's just to use for demonstration. So when this weapon, the Smith & Wesson, ejects, it's going to eject to the right. So someone on their back in a car seat, bucket seats, and somehow like this with another bucket seat and with a handbrake, if it fires, it's going to the right, and that casing is going to bounce around. So how does the casing end up, if you will remain with me, sir? How does the casing end up on the front seat? 44? That seems odd. It's possible. State's Exhibit 44. How does it end up in that passenger seat under a human being? I mean, it can't pass through his flesh. We've talked about shape-shifting enough in jury selection, there's no reason to talk about that again, but this doesn't make sense. Something's not right. And these CSIs, they told you when they got there and took pictures. Did something get moved? They didn't know. And backseat, floor. State's Exhibit 46. So, what happens if the officer is disarmed after he shoots himself, someone doesn't want to be shot, and they remove this to make the weapon safe? Use your common sense, what you know about firearms. How does that get in the back? Well, we don't know how it got in the back because CSI got there later. And you will recall the time. Some of them got there well over an hour, some later. So how did this end up in the back? What's its significance? Was whoever made that weapon safe outside the car, standing here, and it went into the back with the door open in some other way? Don't know. Their burden, reasonable doubt, not guilty. And if I would have Mr. Donovan and demonstrate, as you recall, how the officer was holding it in front of the jury, and you all use your recollection. There's 12 of you. This was a while ago. Officer demonstrated in front of you. So his right finger's right-handed, right trigger finger, he said it was off. But if you'll turn, not pointing, where's that other hand? Where's that other hand? He said he never pulled the trigger, but he didn't know, he couldn't really do a good job of saying who pulled the trigger or how that happened. But something like this, down to the thigh, it'd be burn marks. There'd be something you could see on the hands that they did not put into evidence, the photographs. And that's incredibly important. And then in their closing, they I don't think, mentioned how this could happen. How is this possible to not have burn marks on your hand if you're grabbing the gun? That alone is not guilty as to that assault. Thank you, sir. Good point. So, on the Smith & Wesson 45, there's a slide. So, as they describe, hand on top, can't fire, can't move. It can't cycle. It can't cycle. So, is anything coming out? No. It can't cycle. So, these are all things that are strange. They're inconsistent with the testimony. They're reasonable doubts. Each little part is another reasonable doubt. They didn't explain it in their closing because they can't explain it. It's not consistent with the evidence. And if you don't know what happened, you can't convict under our system of government. Speculation, I think I know what happened, isn't good enough. Can you be entirely convinced and satisfied? So let's talk about intent. Officer Stewart, my recollection is he testified somewhere along the lines, I can't believe you tried to shoot me, and that Mr. Riley told him, I want you to go back to your vehicle, the SUV with the radio, but the doors are closed, and if I'm remembering correctly, if State's Exhibit 2 is substantive evidence, doors are closed. What's in there in addition to the radio that was testified to? What else is in this SUV? They didn't preserve it, they didn't keep it, they didn't put photographs into evidence. What else is in State's Exhibit 2? But the doors are closed. So when did the CSI get there? When did they take this picture? State's Exhibit 25, the broken chain. This was on the ground. The badge, according to the officer, fell to the floor of the Burgundy Compact. So if the struggle happened inside the car, why is this outside the car? Reasonable doubt. They didn't explain it. Was this moved? CSI got there later. There was some testimony, things had been piled up. Things were moved around. So State's Exhibit 29, wastebasket, cuffs, badge. Let's think about the jury instruction. You're going to be instructed about intent. And for robbery with a dangerous weapon or larceny from the person or common law robbery, one of the instructions will tell you a mere temporary taking under circumstances in which the lawful possessor of the property is likely to regain possession does not satisfy this element. So here, these things were found later. Who put them there? The state doesn't tell us, and because they didn't have forensics, we can't tell if multiple people touched this, how it got there, whether the gun was in there, and then someone, we're in Durham, and said, I like that gun, now I'm going to take it. It's a day later. So what happened to the gun? Why does a terrified 21-year-old African American, because that's important, this case is about race, you know, two ways about it. What does he want to do with a handgun, a badge, and cuffs when there's a manhunt for him? And that he'll be shot dead if anyone sees him with that. You've heard all that testimony and all the talk of helicopters that's in the CAD report. He doesn't want to be anywhere near a gun. He doesn't want to die. It's 7 days before Christmas. He wants to live. So all those things, it's not adding up. And it's their burden, and it's a reasonable doubt, which means not guilty. So a taking by a scared 21-year-old because he doesn't want to die isn't intent to rob. It's not an intent to permanently deprive. And it's not an intent to assault someone by moving out of the way and the officer shoots himself, or touching a gun, which apparently he didn't do based on the physical evidence. So what did happen here? If you don't know, and I don't know how you could, they haven't met their burden and it's not guilty. It's not guilty as to each and every charge because they haven't proven any, beyond a reasonable doubt, for each element of each offense. Their burden, reasonable doubt, not guilty. So despite this train that's moving down the track, your responsibility is not to go along with the crowd. Your responsibility is to the Constitution. And you stated you would meet that responsibility. I'd like to read you some of the testimony of Officer Stewart. I told Carlos Riley, get back. I'm going to shoot you. I'm going to shoot you. That's what you told him on the tape, correct, was the question. Answer, yes. Question, get back. I'm going to shoot you. Answer, yes. And you said it twice. Answer, yes. No injuries to the face after a brutal beatdown. It went on for a long time, as he testified to. It was awful, it was brutal. Not a single injury to his face. Not a picture either. But why would they give a picture to show he has no injuries? Look to the point in time when this happened. At the car, when he's freaked, scared out of his mind. He didn't intend to do anything other than live, to see Christmas. He didn't intend to take a gun, do anything with it. He had it up in the air. You heard Ms. Hype's testimony. Ms. Hype's and Officer Stewart, their testimony is totally inconsistent. There wasn't any pointing at him. You don't say, I'm pointing a gun at you and say, I can't believe you tried to shoot me. She said the gun was in the air. She heard a pop, looked out. So Carlos Riley tried to tell the officer to go to his SUV, as was testified to, and he couldn't because he was injured. Did this young man do some things that teenagers or just after teenagers might do that as older folks we say, can't believe you did that? Yeah, but that's not a crime. Being a 21-year-old is not a crime in America right now. He's charged with serious crimes. And any of this evidence that's in evidence, you can ask for it. You can look at it, you can study it. And I commend you to do that if it would be helpful to you, because they have not proven their case. It hasn't come close. And it's their burden. It's not guilty on the hundreds of reasonable doubts that I could sit here for weeks talking to you about, or you can think of yourself, because 12 of you are smarter than one of me. And you made a promise to the Constitution, and you all said, we're going to follow the Constitution. And we give you our affirmation or oath. And we believe you. and you're going to consider this, and you're going to make the right decision. You're going to make a decision based on this evidence, not on the evidence they could have, should have, would have presented, but what happened, what came out in this courtroom, not what was not here. Everything they didn't do, they could have done, but they ask yourself, why didn't they? If they had all this evidence, why did they not present it? So we ask you to respectfully consider this, the failure of the state to prove their case for each and every charge, and come back not guilty, not guilty, not guilty, not guilty, not guilty. Thank you.
Thank you, Mr. Chair. Ladies and gentlemen of the jury, the law in the state of North Carolina requires that jurors be verbally advised or instructed as to the law. The court also has the discretion to provide a written version of what the court will verbally instruct. And I've exercised my discretion to prepare a written version of what I'm going to be instructing you in connection with the charges pending in this case. I'm going to ask that the sheriff distribute that, and don't start reading yet. I'll give you additional instructions related to that document. But let's get one in everybody's hands first. All right, if you don't have a packet, raise your hand. All right, there are no hands raised, so I assume everybody has a packet. Now, what I'm going to suggest to you, and this is for you to follow along. It may assist you in kind of keeping up with instructions, but it's important that you listen to my verbal instructions to you and not try to read ahead or get focused on a different passage that might lead to your not capturing the full effect of the instructions as to the law. So this is a tool for you to have. You can take it into the jury room with you when you begin deliberations. So this time we're going to begin the jury instructions. Members of the jury, all the evidence has been presented. It is now your duty to decide from this evidence what the facts are. You must then apply the law which I am about to give you to those facts. It is absolutely necessary that you understand and apply the law I give it, as I give it to you, not as you think it is or as you might like it to be. This is important because justice requires that everyone tried for the same crime be treated in the same way and have the same law applied. The defendant has entered a plea of not guilty. The fact that the defendant has been charged is no evidence of guilt. Under our system of justice, when a defendant pleads not guilty, the defendant is not required to prove the defendant's innocence. The defendant is presumed to be innocent. The state must prove to you that the defendant is guilty beyond a reasonable doubt. A reasonable doubt is a doubt based on reason and common sense arising out of some or all of the evidence that has been presented, or lack or insufficiency of the evidence as the case may be. Proof beyond a reasonable doubt is proof that fully satisfies or entirely convinces you of the defendant's guilt. You are the sole judges of the believability of witnesses. You must decide for yourselves whether to believe the testimony of any witness You may believe all, any part, or none of a witness's testimony. In deciding whether to believe a witness, you should use the same test of truthfulness that you use in your everyday lives. Among other things, these tests may include the opportunity of the witness to see, hear, know, or remember the facts or occurrences about which the witness testified, the manner and appearance of the witness, any interest, bias, prejudice, or partiality the witness may have, the apparent understanding and fairness of the witness, whether the testimony is reasonable, and whether the testimony is consistent with other believable evidence in the case. You may find that a witness is interested in the outcome of this trial. You may take the witness's interest into account in deciding whether to believe the witness. If you believe the testimony of the witness in whole or in part, you should treat what you believe the same as any other believable evidence. You are the sole judges of the weight to be given in the evidence. If you decide that certain evidence is believable, you must then determine the importance of that evidence in light of all other believable evidence in the case. There are two types of evidence from which you may find the truth as to the facts of a case: direct and circumstantial evidence. Direct evidence is the testimony of one who asserts actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain or a group of facts and circumstances indicating the guilt or innocence of a defendant. The law makes no distinction between the weight to be given to either direct or circumstantial evidence, nor is a greater degree of certainty required of circumstantial evidence than of direct evidence. You should weigh all the evidence in the case. After weighing all the evidence, if you are not convinced of the guilt of the defendant beyond a reasonable doubt, you must find the defendant not guilty. Intent is a mental attitude seldom provable by direct evidence. It must ordinarily be proved by circumstances from which it may be inferred. You arrive at the intent of a person by such just and reasonable deductions from the circumstances proven as a reasonably prudent person would ordinarily draw therefrom. Intent is a mental purpose, aim, or design to perform an act, even though the actor does not necessarily desire the consequences that result. Proof of motive for the crime is permissible and often valuable, but never essential for conviction. If you are convinced beyond a reasonable doubt that the defendant committed the crime, the presence or absence of motive is immaterial. Motive may be shown by facts surrounding the act if they support a reasonable inference of motive. When thus proved, motive becomes a circumstance to be considered by you. The absence of motive is equally a circumstance to be considered on the side of innocence. The state contends that the defendant fled. Evidence of flight may be considered by you together with all other facts and circumstances in this case in determining whether the combined circumstances amount to an admission or show a consciousness of guilt. However, proof of this circumstance is not sufficient in itself to establish defendant's guilt. Certain photographs, diagrams, and maps were introduced into evidence in this case for the purpose of illustrating and explaining the testimony of witnesses. Any photographs, diagrams, and maps admitted into evidence for illustrative purposes may not be considered by you for